this is Melanie Popper here again, discussing recent developments in California law. We're talking about retaliation today. And retaliation is covered under the Fair Employment and Housing Act. I think it's Government Code 12940, Subdivision H, and under Title VII. It's an interesting cause of action because it's easier to litigate than, say, the more controversial claims of discrimination and harassment, hostile work environment. A lot of times judges and juries don't want to, even if they may not say so, they don't want to deal with the politics of taking on those types of claims like race and sex discrimination and harassment. However, if you have retaliation, there's only three main elements to a retaliation claim, and those are these. First, the employee has to complain or oppose some sort of conduct that they believe to be unlawful. And then as a result, that's the causation element, they experience an adverse action. So an example would be someone who complains and says they were being harassed on the basis of race or sex by a supervisor or a coworker, and they complain in writing. They send an email, they send a fax, they have a fax confirmation page. They say, I feel like I'm being harassed on the basis of my whatever, race, sex, religion, disability, whatever protected class. And then shortly after that, they're suspended. They may be told, you really should keep your mouth shut. You shouldn't have gone to the DFEH or the EEOC. You shouldn't have sent that email to us or that fax to us. Just keep quiet. You're suspended without pay, or you're going to have to cut your hours, or you're terminated. That's an unlawful retaliation claim. And then you don't have to go the route of trying to prove the underlying, whether it was actually harassment going on or discrimination going on. You just have to prove those three elements, that the person opposed the conduct or the complaint, what they reasonably believed was unlawful activity. And then as a result of that, that's causation. One thing led to another, and then they've experienced an adverse action. Something bad happened as a result of their complaining, of their going to the DFEH or the EEOC or going to Human Resources, not the union. The union is a lot of times not enough. It's not a direct complaint to the employer. You've got to go to HR or follow the policy or go to the DFEH or the EEOC and make a clear complaint about what you believe to be unlawful conduct. And then as a result of that, if you experience a really serious negative thing, it's a fairly easy to prove claim, retaliation under California law.